Welcome to the Judicial Committee of the Privy Council. Today we are hearing an appeal from the Court of Appeal of Trinidad and Tobago in the case Nature Resorts Limited against First Citizens Bank Limited. I'm Lord Briggs. Sitting with me are Lady Arden, Lord Kitchen.
Hello.
Lord Burrows.
Hello.
And Lady Rose.
Hello.
Counsel for the appellant, Nature Resorts Limited, are Mr Westgate, Queen's Counsel, and Mr Singh. And counsel for the respondent is Mr Gilks. The main issue in the case is whether the Court of Appeal and the trial judge were wrong to reject a claim by the appellant company that a charge over its principal asset in favour of the respondent bank was procured by undue influence and therefore voidable. We will take a short break at the end of the appellant's submissions, and bearing in mind our late start, we'll consider whether it's necessary to extend the hearing a little beyond the current deadline of 4 o'clock. Yes, Mr Westgate. You're muted, Mr Westgate.
Thank you. I'm grateful, my lord. I'm very conscious of the time, the restricted time that we have to deal with this, and so I don't propose, unless the court wishes me to do so, to take up time going through the background or the facts. So far as we're concerned, NRL are content to adopt the statement of facts in the decision of the Court of Appeal in relation to the background to this matter, up to paragraph 41. And specifically, we accept that we can't go behind the facts found by the judge about Mr Dankou's knowledge of the mortgage, or the fact that it was a mortgage, and the rejection recited in the Court of Appeal's decision of the claimed close ties between him and Mr Wheeler. But we do emphasise the limitations on those findings. We've set some of those out in our case at paragraph 5. And in particular, there was no finding that Mr Dankou was aware that a mortgage was to be sought on the land before the meeting that took place on the 28th of March. And that the background documentation suggests that he hadn't been copied into any of the correspondence about that. Secondly, and although he was a businessman and was described by Mrs Justice Pemberton as au courant with commercial reality, his unchallenged evidence was that he'd never previously entered a mortgage. That's from his affidavit at page 274. And as accepted by the Court of Appeal, the evidence didn't suggest that he had explained to him the effect of the mortgage on his shares if the property ended up being sold, beyond the technically accurate statement that his shares weren't being charged. And the mortgage granted in this case was in addition to a security already granted over the 75% shareholding held by Paler and James, and it was an all-monies charge. So with that brief background point on the evidence, so far as the issues are concerned, as far as the legal issues are concerned, as noted by the Court of Appeal, there's little dispute about the broad principles about when undue influence can be established, and the Court of Appeal concisely crystallised that by asking firstly whether there was a relationship of influence, secondly whether the transaction was one that called for an explanation, and on proof of those two matters, as they put it, the stage was set to presume that there had been undue influence, and the next question was then rebuttal. And those three stages were the way that the Court of Appeal approached it, and there doesn't appear to be any dispute in broad terms between the parties that it was entitled to approach the matter in that way. That's our case, paragraph 10, the respondent's case, paragraph 22. As regards the first of those points, it's now common ground that there was presumed to be a relationship of influence. That's our case, paragraph 17 to 18, the respondent's case 33. That is a submission, an acceptance that we say is clearly right, given the timing of Mr Wheeler's previous involvement and his involvement in preparing the related transactions in this case, such as the share transfers, the promissory note, and the shareholders' agreement. And all of those, in effect, ran together with the mortgage. But for our part, we, of course, accept that the inference only goes so far as influence and not undue influence. In order to raise a presumption of undue influence, something more is needed, i.e. a transaction that calls for an explanation and where on the facts. And so what we understand to be an issue is three issues in relation to the undue influence claim, which is whether the transaction is one, firstly, whether the transaction is one that calls for an explanation so as to give rise to a rebuttable presumption of undue influence. That's something the respondents put in issue at paragraphs 32 to 4 of their case. Whether, if so, it was open to the Court of Appeal to hold that the presumption was rebutted. That's the thrust of the appellant's appeal. And if it hasn't been rebutted, then whether the bank is bound. That's in effect the thrust of the respondent's cross appeal. The respondent runs together the first and third, but we suggest they raise distinct issues and are better dealt with separately, and that's what I propose to do. But there is, of course, a fourth issue, which is that the board asked the parties to address the application of Section 56 of the Trinidad Companies Act about financial assistance, and I'll come on to deal with that separately after I've dealt with the undue influence points. So, dealing first of all then, whether this is a transaction that calls for an explanation so as to be capable of founding a rebuttable presumption. Having held that there was a relevant relationship of trust and confidence, the Court of Appeal approached that on the basis that what had to be considered was the mortgage transaction between Nature Resorts and the bank, and the balance of advantage and disadvantage in that transaction between those parties. And they held that the transaction was one that called for an explanation. In doing so, they expressly directed themselves by reference to the test in Ettridge, and that's paragraph 51 of their judgment, citing Lord Nichols in Ettridge at 22 to 5. So they had the right focus of the test in mind, and they held that given the lack of benefits to the company and the corresponding benefit to the bank, this was a transaction that called for an explanation within the meaning of that test. And it's important to recognise, we say, that there's no challenge from the respondent to that evaluation of the respective advantages or disadvantages of the transaction if one focuses on that transaction. And we respectfully suggest that it was a conclusion that was plainly open to the Court of Appeal to reach it. And we've given some further supporting points in our case, but I won't take you to those. They're at paragraph 23. The respondent's argument has a different focus, and instead it rests on the observation that because Mr. Wheeler didn't benefit from the transaction, and the transaction wasn't made between Mr. Wheeler and the bank and Nature Resorts for Mr. Wheeler's benefit, they say that the effect of that is that the transaction isn't one that calls for an explanation, and they develop that in their arguments about whether or not the bank is bound to suggest that it's an error in the context of presumed undue influence to combine a confidential relationship between a solicitor and client, those being two parties, and a transaction between different parties, that being the client and the bank in this case. And we suggest that simply doesn't provide an answer to an undue influence claim in this case, and it's perfectly orthodox in principle for Nature Resorts to frame their undue influence claim in the way that they do. And there are really four elements to that. Firstly, that the equity to relieve against undue influence applies where the alleged wrongdoer, by which we include a wrongdoer by the application of the presumption influences a transaction between the subject of the influence and a third party. The second point is often, and as a matter of fact, that will be for the personal gain of the wrongdoer, but that's not and has never been a requirement to establish an undue influence. Thirdly, that is, we say, consistent with the underlying justification for the exercise of the equity to relieve from undue influence. And fourthly, we say that specifically where a solicitor enters into a transaction in respect of someone for whom they stand in a relationship of influence for the benefit of or on behalf of another party, that's within the scope of the doctrine. So the first point, that is a transaction between the subject of the influence and a third party, is, we suggest, something that can clearly be seen from the O'Brien and Ettridge line of cases. And indeed, it's something which is exemplified by very many surety cases, because what relevantly affected the wives in those cases, or the other people standing in non-commercial relationships, wasn't the husband's borrowing or any transaction between them and their husbands, but their agreement with the bank to stand surety. And although in very many of those cases, the husbands were also people with an interest in the home that was given a security, that's not necessarily the case, and the husband stroke influencer need not be a party to the transaction at all. And so in principle, and as was explained in O'Brien and Ettridge, that there was an equity against the husband in relation to the transaction, but since they weren't a party to it, it would give rise to no meaningful remedy against them. And we suggest it's obvious in those cases that the transaction that calls for an explanation is the one that was the subject of the influence, i.e. the mortgage, even though that's not a transaction between the influencer and the influenced party. So the foundation for the respondent's objection, we say, isn't made out of, really for that reason alone, because what the task for the court then is to evaluate that transaction, and that's what the Court of Appeal did in this case at paragraphs 52 to 53. The second point we make is it's not necessary for the influencer to benefit. We of course accept that in the typical Ettridge type case, the influencer gains a benefit because they get security for a loan that may perhaps not be granted but for that security. But it's never been a requirement that there be a personal benefit of that kind, and that can be seen going back to Alcard and Skinner. That's tab 5 of your authorities bundle, of the authorities, which is I think at page 1242 of the bundle. I perhaps don't need to take you to it in any detail. As you know, it was a case where the Ms. Alcard was introduced by her spiritual advisor, Reverend Neil, to a sisterhood that she joined. The Reverend wasn't actually a member of that, but he had founded it and was a confessor and treasurer. But she gave all her property to the order in form that was to Skinner, who was the Lady Superior, who held on trust. And there are 2 points I draw from that case. The first is that there was, both on the part of the Reverend Nihil and Ms. Skinner, a complete absence of personal gain, and that was something that the court was at pains to acquit them of. And so at page 1269, and I won't take you to these passages, Lord Justice Cotton noted that there was no suggestion of any selfish motive, and at page 1276, Lord Justice Lindley noted that not a farthing had been spent for any purpose other than legitimate objects of the sisterhood. The second point I draw from that case is that influence exerted by a person who didn't themselves benefit is sufficient. And so the head note accurately reflects that Alcard was subject to the influence of both the Lady Superior, who did derive a benefit but as trustee, and the Reverend Nihil. And it's clear that from his discussion, Lord Justice Lindley treated the influence of both of those people as the same. So if I can take you to page 147, sorry, no, not 1279, please. I picked this point up. It's the bottom of page 1279. I pick it up for the statement of principle, where Lord Justice Lindley contrasts: is it right and expedient to save persons from the consequences of their own folly, or is it right and expedient to save them from being victimized by the people? In my opinion, the doctrine of undue influence is founded on the second of these two principles. And then he goes on at page 180 in the bundle, if about halfway down, it's about a third of the way down the second main paragraph there, he says that...
okay, what page are you on now?
It's page 1280 of the bundle.
Yes.
It's page 183 of the report.
Yes.
He says, he points out that no court's ever attempted to define undue influence. And he then goes on to say that the influence of one mind over another is very subtle, and points out the dangers of religious influence and its power. And then at the bottom of the page, he says, in this particular case, I can't find any proof that any gift made by the plaintiff was the result of any actual exercise of power or influence on the part of the Lady Superior or Mr Nihil, apart from the influence necessarily incidental to their position in the sisterhood. And then at the next page, about 8 lines down on the second block of text, he says, she was absolutely in the power of the Lady Superior and Mr Nihil. Gift made by her under these circumstances, the Lady Superior, can't, in my opinion, be retained by the donee. So, of course, what's clear from that passage is that Lord Justice Lindley would have reached the same result if the influence had simply come from Mr Nihil and not the Lady Superior. But that appears to be the case, because he treats them both as the same, and that we say is supported by the head note. The point we make, again, there's no need for the person exerting the influence to benefit, is also made by 2 authorities that we've included in a supplemental bundle, which I hope you have. The first of those is Bullock and Lloyd's Bank, 1954, Chancery 317, which is at page 1819 of the supplemental of the bundle. And if you have it, I don't need to take you any further than page 1826 of the bundle, and it's this was a case where a settlement was executed under the influence of the settlor's father, although she did receive some advice from a solicitor, but that was the father's solicitor. And
excuse me, Mr Westgate, which page of the report is that? Because I seem only to have this as a separate bundle with its own independent pagination.
I'm sorry, it's page 324 of the report.
Thank you.
And the passage I want is, it reflects the head note, which is the second paragraph there, acquitting the solicitor anything more than a certain measure of carelessness. Someone goes on to the 5th line there. The expression undue influence is, to my mind, one of ambiguous import. It's not confined to those cases in which the influence is exerted to secure a benefit for the person exerting it, but extends also to cases in which a person with imperfect judgment is placed or places himself under the direction of one possessing not only greater experience, but also such force as that which is inherent in such a relationship as that between father and his own child. but it's the first part of that I rely on. That it's not necessary for the influencer to benefit. In that case, that the father did in fact benefit because he was one of the beneficiaries of the settlement. And then the second authority that we rely on is Willis and Barron, which was it's page 1830, and that was a case where a settlor approached her husband's solicitor as family solicitor for advice, and conferred a benefit on the solicitor's son. Of course, it might then be said that the solicitor does benefit in some way from that. But when one comes to page 281 of the internal pagination of the report's pagination, page 1840 of the bundle, and it's the second paragraph up from the bottom of Lord Macnaghten. He says it's about 10 lines up from the bottom of that, putting out of consideration the fact that Mr. Skinner's son got a great advantage. I must say, even if the person who was the ultimate remainder had no connection with Mr. Skinner, his solicitor, there would have been ample ground to set aside this deed, considering Mr. Skinner was her family solicitor, a person to whom she would naturally go for advice, and he was also her trustee. It makes it rather stronger when you see that the effect of this alteration was to make certain or almost certain a gift in favour of his son.
Was this another case of a gift? Yes.
It was a gift, yes.
Yes. Mr. Westgate, it can't be the law, can it, that if one's own solicitor, in whom one naturally reposes trust and confidence, advises one to enter into a thoroughly disadvantageous commercial transaction, which one might think called for an explanation, that one could say, well, I entered into it as a result of my solicitor's undue influence?
Certainly, as a general proposition, we certainly wouldn't go that far.
So what is, if anything, is the nexus which needs to exist between the perpetrator of the undue influence and the person who, under the consequential transaction, is benefited? Or is it simply notice?
If one comes back to the three, the first two elements that are necessary to give rise to the presumption, the first is a relationship with influence, and although we don't say as a general proposition that anyone acting simply on advice from a solicitor must be presumed to have been unduly influenced in doing so, the fact is that is a relationship where proposals or advice are very often going to be ones which will be acted upon. And in that sense, the client is under the influence of their solicitor, and and so what one has to ask first of all is whether the relationship is one that can give rise to an inference that the transaction itself was the product of that influence. And
well, it is if the solicitor advises the client to enter into it, then it is the product of influence. But the problem is that doesn't, although that may give you a cause of action against your solicitor, it hasn't previously been thought that it entitled you to set aside the transaction if the other party knew, as they're likely to do, that you've hired a solicitor to help you. So at what point is there a break in what you seem to be saying is the inexorable chain that of presumed influence plus a very disadvantageous transaction, plus the other party knows that you've used a solicitor who presumably has influence over you. So what is it that stops any client then being able to set aside that transaction?
Well, what one has here, and the critical feature in this case that won't be present in most straightforward solicitor-client cases, although we don't want to be understood to say that can never give right. So you could, for example, have a client who is persuaded by their solicitor to make a gift to a particular institution or something of that kind. But the particular feature of this case is that the solicitor is acting to benefit one of their other clients.
Acting to benefit in what sense? I mean, presumably both sides usually benefit from entering in into a transaction. That's why they do it.
Well, indeed, but
both think that they get a benefit out of it. So again, in lots of cases, a solicitor will act for both sides in a transaction if it's not interest.
Well, that's where the
an efficient way of dealing with things. So how is it that doesn't always then later entitle the party who's unhappy later with the bargain to say, well, it was entered into under the solicitor's presumed influence and it's disadvantageous and you knew and I want to get out of it now?
The short answer to that is in the control, and this was one of the points that was arose in Ettridge, where what was the reason why Lord Nichols rejected the call in that case to dispense with the need for a disadvantageous transaction altogether, and simply to place the test on influence alone. But because the control is going to be that the transaction is one which calls for an explanation. So it's not simply a case where someone ends up being dissatisfied with the transaction that was entered into. It has to cross that threshold.
But what is that threshold beyond it being very disadvantageous to one side and advantageous to the other side?
Well,
if it's not benefit to the influencer, what is it that calls for an explanation?
Well, the existence of benefit in this case, or rather, to the extent that one does need to have benefit, then one finds it in a case where a solicitor is acting for the benefiting party, and that that's clearly the case where certainly we draw attention to the allied field of breach of confidence. That's clearly the case where where a solicitor in a relationship of confidence with one person deals with them on behalf of another client, and that can run from a range of different ways of dealing with them. They might do it as trustee for the other client, but there's no reason why it should be confined to that kind of case. They might get involved in negotiating something of that kind, and so what one has is a relationship of dealing with the client, the influenced party, who's someone who's in a position thereby to be influenced in the course of that transaction, and doing it on behalf of someone who benefits as the solicitor's client, and that we say would be consistent with the distinction that's drawn in the confidence cases, where one has the distinction between acting for a client and dealing with them. And that's a distinction that's drawn in EBS and Johnson, where the passage we rely on is page 1381.
Mr. Westgate.
Oh, yes.
Yes. Can I just ask a question? So, as I understand it, we're now trying to pinpoint what the test of calling for an explanation requires in this particular context. And I think you're telling us that the need for there to be an explanation, or rather this transaction is not one that is explicable by ordinary motives, is not to do with whether that transaction is advantageous or disadvantageous, it's rather the role that Mr. Wheeler was here performing. Is that right?
Well, it's the ordinarily when one asks what the what it is that calls for an explanation and transaction, then you will look at the nature of the transaction and ask whether it's and look at the balance of advantages and disadvantages. But for the reason that was put to me by Lady Rose, it's not something that one has to find a way of distinguishing between that class of case and cases where there is simply bad advice given to a client, and there are, we suggest, two limiting factors. One is the role that the solicitor plays, where we suggest it is instructive to look at the way in which the EBS case drew a distinction between acting for and dealing with. And it's then a question of where one fits that in to the sequence of questions that the Court of Appeal asked themselves here, because in one sense, that's something that goes most naturally to the point whether the presumption's been rebutted, rather than because one would simply say, well, it was a fairly glancing involvement by the solicitor, and there was no opportunity for the influence that they had to act on the transaction. But it might also come in at the first stage of asking whether there is room for a presumption of influence in that transaction at all. I accept it. It's less easy to see how it fits into whether or not the transaction is one that calls for an explanation, except in the sense that where the transactions between an influenced party and either the solicitor or another client of the solicitor are ones that are less readily explicable by reasons of ordinary motives. But
the way you're putting it, Mr. Westgate, makes it sound as if every time two parties enter into a transaction with each other, where a solicitor is acting for both sides, then whichever one turns out to have had the thin end of the bargain can say, well, I was under the influence of the solicitor, therefore the transaction should be, it's a disadvantageous transaction to me. He was, if you like, dealing with me on behalf of his other client, and therefore it ought to be set aside. It sounds quite a far-reaching proposition, put that way.
Well, which is why we do stress the nature of the involvement, because in a case where you have a solicitor acting in a purely administrative way for both parties, then what one can see that the deal is being done. The solicitor's just carrying into effect those instructions. But there are but there may well be a different situation where there's negotiation that happens or needs to happen, or whether the positions of the parties are in conflict in a way that hasn't been resolved by clear discussion between them, or the fact that it's a routine transaction on standard terms or something of that kind. When one looks at what was happening in this case, it's a transaction of a kind, and I'll come to this when we come to the point about rebutting the presumption and the need for independent evidence, independent advice. That this was the kind of transaction that was full of matters that, if Mr Dankou was to be properly advised, would necessarily involve the Mr Wheeler acting in conflict with the bank and vice versa. And so it's not an unusual proposition that solicitors can act for both parties, but when they do, they've got to be very careful not
they
put
have to
themselves
be,
in a position.
yeah, they have to be very careful because they have a conflict of interest. And that usually means that one of the sides has an action against them. But here, nobody's suing Mr. Wheeler for breach of his duties to them. And in fact, if it's the case, as my Lord Briggs suggests, that one could always set aside the transaction, then it may be that they're right not to sue Mr. Wheeler. But there are lots of cases where people sue their solicitors or other fiduciaries for conflict of interest, where the basis of that claim is that they are then bound by the transaction with the other side, and that's what they're complaining about. But if they're not bound by the transaction, it's surprising that's not been made clear before in all those cases against negligent solicitors or fiduciaries who are acting to principles.
Well, if the in a case of a fiduciary who's acting for two principles, then it's going to depend on the transaction whether it can be set aside. In very many of those kind of cases, there will be that there's no effective remedy in setting aside. But the question that we are asking the court to address is whether, if one starts from first principles, a solicitor who acts on their own behalf obviously will be within the principle. A solicitor we suggest who acts as trustee will clearly be within the principle. There is no in principle dividing line between a solicitor who acts as trustee in that sense on behalf of another party and one who acts so as to procure a result for another client. And the question really is where one falls on that dividing line, because we do accept that there's a dividing line between simply acting for someone in an agreed transaction, and because in that case there's little room for saying that there has actually been a influence exerted, and in a case where the solicitor gets involved in the dealing. And where that line falls is a matter of judgment, and it's one that we suggest is something that can depend on the particular circumstances prevailing in a particular jurisdiction, because it's going to depend on practice from time to time. And I understand that in Trinidad, the practice isn't, for example, for the same solicitor to act for the bank and give advice to a non-commercial surety. So in the Ettridge kind of case, where the solicitor's acting for the bank, then they don't act for the wife as well. And it's matters like that that may have a bearing on where a case lies. And ultimately, this is a decision within the ambit of the Court of Appeal in this case, that they were entitled to hold that this was a relationship of a kind that gave rise to, or was capable of giving rise to the presumption. That's not ruled out as a matter of principle for the reasons we've said, because although one has to draw a line somewhere, that there's no reason why the relationship of solicitor and client, being one of presumed influence, shouldn't also apply to other transactions, other than cases where a solicitor themselves takes a benefit, or the solicitor themselves receives a gift.
Anyway, you have the Court of Appeal in your favour on this point, and it's you're already staving off the respondents at this stage in your argument.
That's right.
Yes.
But it's But we do say it flows as really as a matter of principle. And again, when one goes back to Lord Justice Lindley in Alcott and Skinner, that was what's being protected against is the victimisation of the weaker party or the influenced party. And so what one should be focusing on as a matter of principle is why they acted as they did, rather than necessarily who benefited. And it's clear from the authorities I've shown you that third parties can benefit without the influence of benefiting. So that is the first point, and I hope I can move a little more quickly with the others because time is marching on. The second point is, has the presumption been rebutted if it's arisen? And at that stage, we without repeating our case, we emphasise firstly that rebuttal is not achieved simply by showing a reasonable explanation for the transaction. Secondly, we accept that legal advice isn't always necessary. And thirdly, we make the point that the fact that the influenced party understood the nature of the transaction is a necessary but not decisive consideration. Someone might, after all, understand the implications, but think that because it's proposed or endorsed by somebody they trust, that it's all for the best, or think they've got no alternative or something of that kind. And we suggest for that reason that the requirements of independence and legal advice run together, that the person influenced has to be removed from the influencer, and they must know what they're doing and the full implications of it. And both those elements are reflected by Lord Justice Fletcher Moulton in Re Coomber. It's page 1435. I don't need to take you to it, where he said the advice shall be removed from the suspected atmosphere and from the clear language of an independent mind. They should know precisely what they're doing. Mrs. Justice Pemberton didn't deal with this in terms, so the Court of Appeal reached its own conclusion. The reason we draw attention to that is for the point that we make in our case, that this isn't a case of concurrent findings, because it's a decision by the Court of Appeal who reached the judgment they did and the fact findings they did on the material that appeared to them, and of course this court's in the same position. And the court, we suggest, misdirected itself in three ways. Firstly, it didn't fully understand what independence required here, and its failure to find that independent advice was needed in this case can't be reconciled with the earlier findings and presumption, and its judgment, and that's plainly wrong. Secondly, it fell into error in finding that because Mr Dankou entered into the share transfer of his own free will, the same read across to the mortgage. And thirdly, there wasn't material on which you could conclude that Mr Dankou was aware of the effect of the sale on his shares. And if I can deal with the independent advice point first, it's clear there was no independent advice, and the background we say is important. That we reiterate the point that Mr Dankou wasn't on the findings aware of the mortgage before the meeting on the 28th of March, and so he had to assimilate and deal with that transaction in what was a relatively short meeting. That there weren't any findings about timing, but Ms Mohammed, the company secretary, said it was 20 to 30 minutes. Mr Wheeler said 1.5 hours, but on any view, it was a fairly self-contained meeting. And so what happened was, Mr Dankou went in there. He was presented with the documents, including the mortgage, and Mr Wheeler, the presumed influencer, was there throughout. And this is against the background where the Court of Appeal's findings are that not only did he have influence over Mr Dankou, he was presumed to have exercised it unduly. And the only explanation given about the mortgage was given by Mr Wheeler. And unsurprisingly, he didn't give the kind of advice that you might have expected from an independent advisor. So there was no discussion about the burdens imposed by the mortgage, and that it was more money is charged, the likelihood or risks of default, the options open to the bank about perhaps enforcing on the shares first, other securities that Taylor and James could give, the amount that the bank would be obliged to sell the property for if they did default. No discussion about the practical impact on Mr Dankou's shares, and of course, no discussion about Section 56 of the Companies Act, although I can put that to one side for the time being. But what we say is that those factors. I'm sorry. Yes,
yes.
Lady Rose.
I mean, Mr Dankou was there in two capacities, wasn't he? And he signed the documents in two different capacities: in his personal capacity as a shareholder, and in his capacity as director of Nature Resorts. And it was in that latter capacity that I signed the mortgage on behalf of Nature Resorts. So in which of those capacities, or is it in both of them, that Mr Wheeler had presumed influence over him? And in the explanations that you say he should have been giving, was he giving those explanations to Mr Dankou in his capacity as shareholder, who of course benefited very much from the giving of the security, or in his capacity as director and guiding mind of Nature Resorts, which did not benefit?
Well, he was the findings of Mrs Justice Pemberton were that NRL and Mr Dankou could be treated as one, and of course NRL is the for the purposes of the transaction. Of course, NRL was a party to it. For the purposes of deciding whether or not there's undue influence here, it's idle to pretend that the person signing doesn't bring their own interests to bear on this, in the sense that what we're asking for here is an explanation for the transaction. And so Mr Wheeler would have, or the explanations that were needed were ones that were due to Mr Wheeler and, I'm sorry, Mr Dankou in both those capacities. But because in fact the transaction had disadvantages both for Mr Dankou and the company. And it's, although Mr Dankou was to receive funds and so had an interest in the share transaction proceeding, it doesn't follow that he benefited from the mortgage transaction. And
he clearly did, because the position was that the buyers of his shares for a very large sum of money indeed couldn't raise the money to pay for those shares without the mortgage.
Well, they couldn't raise it without a loan, and Mr Dankou and NRL had no negotiation with the bank, no contact with the bank. We don't know whether Polar and James would have been able to put up other security for themselves for the money that they received.
I mean, the money, however you put it, the money was coming from the bank.
Well, the money was certainly coming from the bank, but given the disadvantages of mortgage, and given the fact that it was given at a time when Mr Dankou and by extension the company, if the company benefited, because debtors were paid off and so on, that the creditors were paid off, they didn't even receive all the money that was lent, because the only £1.5 million was paid over. And so both Mr Dankou and the company lost out in that sense. But also all of this happened in a process of some urgency, in a sense, because it all happened on the 28th of March, which was an entirely artificial position to be in. If, for example, Mr Dankou and the company had been given an opportunity to reflect with the benefit of advice, when what they might have done is gone back to the bank and sought to negotiate other parts of the charge. They might have raised questions about other security being available. They might have sought some provision to the effect that there'd be enforcement against the shares rather than the property first off. All of those would have protected Mr Dankou and would have gone some way to protecting the company. So it's and the fact none of that happened. and there wasn't even any discussion about any of that. And it would have been extremely difficult for Mr. Wheeler to enter into a discussion because in doing so, he'd be saying, well, look, the bank have instructed me to secure completion of this mortgage, but actually there are all sorts of things that you ought to be going back to them. And none of that discussion happened, whether for the benefit of Mr. Dankou in his own capacity or whether for the benefit of the company. And for these purposes, we don't necessarily accept that there is a clear divide between them, because what we're concerned about here is the security rather than the loan. And if it turned out at the end of the day that this was the only way that the loan could have been secured, then that's something that Mr. Dankou and the company would have to thought about. But we don't know where they would have been if they had carried out further discussions. So the reason I draw attention to all those factors is really to make the point that this wasn't a straightforward case. There was a lot to consider, a lot to weigh up, and it's precisely the kind of thing where further consideration and further advice was needed. And moreover, it's not a case where anything was done to mitigate the lack of independent advice, because there was no discussion by Mr. Wheeler about his role. He was at pains, and the bank were at pains, to point out that he was only instructed by the bank. But it's far from clear that that was the position that was understood at the meeting. And there seems to have been a level of looseness about who was advising whom and for what purpose. And hence, Mr. Wheeler, who was only acting for the bank, gave Mr. Dankou advice about the mortgage and answered the question about whether or not his shares were being charged.
But it wasn't Mr. Wheeler's only capacity. He was also a director of the company.
Yes, he was.
So Mr. Dankou would be in an environment in which he would expect his co-director to draw attention to any disadvantageous matter or any matter which might relate to the decision of the directors of NRL.
Well, yes, well, the opposite would be true as well. Mr. Dankou would expect of Mr. Wheeler.
Yes. So that's part of this whole picture we're looking at.
Oh, yes, and certainly one of the points we make in suggesting that this is an influence case is to rely on the dual role of Mr. Wheeler as director and shareholder, and so the impression that's being given is that his advice is in the best interest of the company,
Or that at least he would be doing much the same job as a director.
Mr. Wheeler would be, yes.
Yes, but taking account of his duty of skill and care, given that it would include his legal knowledge, he'd have to show not only that he personally exercised due skill and care, but that he did what was required of a person with his particular attributes.
Yes. And
but as I understand it, Mr. Westgate, the only main point taken in this context is it said Mr. Dankou didn't realise that a mortgage of the shares could affect, or the enforcement of a mortgage of the shares could affect his shareholding and the value of his shareholding in the company.
That's the specific point that Mr. Dankou relies on as going to his lack of understanding.
It does seem, I mean, it's asking quite a lot, isn't it, to expect the court to think that a businessman who's been involved in this development for some time, this proposed development, doesn't understand that if the company in which he has a shareholding charges the company's only property with repayment of a loan to third parties, in this context the two purchasers, enforcement of that charge is not going to affect the value of his shares. It seems to be so obvious that it is. I find it quite difficult to swallow the notion that he could have been in ignorance of that.
Well, it's
he may have said so, but of course, I don't think the judge accepted that, did she?
Well, it's one of those points that it's fair to say didn't feature a great deal in the hearing at first instance, because it arises out of, in some respects, Mr. Wheeler's evidence, because Mr. Wheeler was the one who said there was a query raised about the 25%, and then once he said that it was wasn't charged, then Mr. Dankou signed. And so there doesn't appear to have been a great deal of focus on it at first instance, but it is instructive to look at the way that the judge dealt with it at first instance, because it's, although, my lord, in one sense it seems obvious that if you are a shareholder in a company and the company's got an asset and the company loses that asset, that's going to impact your shareholder. This is a case where the loan was to buy a 70% interest in the company, but the parties seem to have used the 75% interest in the company and 75% interest in the estate somewhat interchangeably. You may have seen from the letter from the bank that it talked about buying the property, when of course they weren't buying the property, they were just buying a shareholding. And so it's perhaps easier to understand why in that context some misunderstanding can arise, and you can think, well, if that Taylor and James have got a 75% interest in the property, and that's what's being charged, rather than fully appreciating that the entire property is being charged, and of course, if the property gets sold for a lot more than covers the loan, then there may be enough to pay out some of the shares, but that may not happen, particularly on a forced sale. And that sort of confusion, or at least the seeds of that sort of confusion, one can see reflected to a certain extent in the propositions that Mrs. Justice Pemberton set out at the beginning of her judgment. It's page 220 of the bundle. It's in the key documents bundle at tab 8. And she refers to at point 7, PD's 25% shareholding isn't affected. And then she says PD's 25% ownership of the estate through its shareholding in NRL is unaffected and unencumbered by the mortgage transaction. Well, in one sense that's true, but if it's true in respect to PD's shareholding, it's also true in respect of Taylor and James, in that the shareholding isn't affected by the mortgage at all. And then she goes on and says, thus any judgment which may be granted will not affect and shall be subject to PD's 25% share of the estate. And so it's easy to see why that sort of confusion might arise, and why it's something that does need separate advice, particularly for someone who, although he's a businessman, hasn't entered into a mortgage before. And what the Court of Appeal failed to ask themselves was, well, how are the matters that we're relying on, how do they relate to this particular finding of fact that we're going on to make, that he knew or must have known about the effect on his shares? So that their error, as it were, was to jump from observing that he's a businessman to concluding that he must know about mortgages, when it doesn't necessarily follow. I think it covers the 2 points I wanted to make about the independent advice, or 2 of the 3 points. The third one we rely on is the having regard to what we would characterise as irrelevant considerations, because what matters at this stage of the inquiry is whether Mr. Dankou exercised a free will in relation to the mortgage, and he don't answer that question by pointing out that he had other transactions that he entered into of his own free will, or by pointing to the motives of other parties. But that's what the Court of Appeal did, because they refer to his voluntary decision to sell his shares, that's paragraph 57, that he had an interest in seeing the transaction through to completion, that's paragraph 58, and that and at paragraph 63 to 4, they refer to the reasons that the bank might have had for requiring a mortgage, but none of that goes to whether Mr Dankou, on behalf of NRL, entered into the mortgage on behalf with his own free will. So before I leave this point, if I can just recap on the points I make about this being a case where there was a need for independent advice. So I've already pointed to the complexity of the transaction, and that's so whether one looks at it from the perspective of nature resorts or Mr Dankou. And I've also pointed to the fact that it's a case where Mr Wheeler would have been in difficulty giving impartial advice to both parties. But this is a case where if there'd been a full explanation that Mr Wheeler had given that he wasn't, in fact, acting for Mr Dankou or NRL, and that he was acting solely for the bank, then that would have alerted Mr Dankou on his own behalf or on behalf of NRL to the fact that, putting it bluntly, not everyone in the room was on his side, and that there may be things that needed some independent evaluation, and that was the thing that was missing here, and the error in the Court of Appeal's decision, and it's really repeated in the respondents' attempts to uphold this finding, is that they wrongly equate the fact that he understood that he was signing a mortgage with his understanding of the full consequences, and with the fact, and what they fail to address is the fact that one starts from a proposition that Mr Wheeler has been presumed to have exerted undue influence. At that point, the burden lies on Mr Wheeler, the bank, rather, the burden lies on the bank, to demonstrate that it was entered into by Mr Dankou NRL's free will, and if they'd approached it with an understanding of the nature of the transaction and why it was that it called for an independent eye, and with an eye to the burden of proof, then they couldn't have reached the decision they did, and it's plainly wrong for them to have done it, not to have held that the burden hadn't been discharged because of the failure to give independent advice. Can I come on then to the third of the points that I'd identified, which I hope I can take fairly swiftly, which is that if there was undue influence demonstrated here, then is the bank bound? And we suggest the Court of Appeal dealt with that correctly, paragraph 40, that there's no doubt that Mr Wheeler was the bank's agent, and the bank doesn't appear to argue otherwise. If the analysis accepted that the presumed undue influence is established against Wheeler, then he did so as the bank's agent, and the bank are bound by that. And the respondent's argument to the contrary is paragraphs 36 to 7 of their case, where they make two related claims. One is that the operation of the agency principles is limited to cases of actual influence, and secondly, that at least in presumed cases, the courts have applied notice in preference to agency, but that, we say, isn't what the cases say. They make clear that agency, where it applies, remains a route to establishing liability for the principal, and also that both agency and notice apply to actual and presumed undue influence, and one can't draw a distinction between them. And the starting point for that, and I can perhaps, well, if I can ask you to Barclays and O'Brien, which is tab 6, page 1291 of the bundle. And at page 1300, Lord Brown-Wilkinson set out the division into classes 1, 2, and 2A and 2B. The it's since been simplified, but that doesn't matter for the purpose of this point. One then goes to page 1302, where he addresses undue influence, misrepresentation of third parties. And at C, he says this: of course, if the wrongdoing husband is acting as agent for the creditor bank and obtaining surety for the wife, the creditor will be fixed with the wrongdoing of its own agent. The surety contract can be set aside against the creditor. And then he goes on to talk about notice, actual or constructive. Now, this is something that follows immediately from his classification of classes 1 and 2, A and B. If what he was intending to say was, of course, if in a case of actual undue influence, the wrongdoing husband's acting as agent, then he would have said so. But it's obvious that he's including both these alternative ways of establishing liability for all classes of undue influence. And one can't get anything from the reference to the wrongdoing husband, because he refers to wrongdoer in class 2B at 130H. So he's clearly got in mind that a presumed undue influencer is a wrongdoer for these purposes. And he makes a similar point, I won't take you to it, at 1306F, where again he draws no distinction between those two kinds of case. And as the case makes clear, it's not a turning away from agency principles, or the relevance of O'Brien was to finally make the point that in very many husband and wife cases it was unrealistic to refer to the husband as agent. What Lord Brown Wilkinson isn't doing is saying that henceforth these cases will be dealt with on notice principles and not agency. He's simply making the point when he discusses terminal interval that this is that you won't normally have an agency relationship in this kind of case. And indeed, terminal interval may be an example itself of presumed wrongdoing by an agent, because that was a case where a benefit was obtained by a trustee from their Sedity trust. That was the first basis for the decision, which Lord Brown Wilkinson at page 1302 to 3 expressly said raises no problems. And in that case, it can only have raised no problems if the ultimate beneficiary was liable for the actions of their trustee, of their agent, in their capacity as trustee. But the second case we'd refer to on this point, which we say puts the point beyond doubt, is a booty, and that's tab 7. And if I can ask you to go to page 1360, it's page 972 of the report. Lord Justice Slade says there, at letter B, some confusion may have been caused by the use of the word agent. We're not concerned here with the question as to whether or not the bank's vicarious responsible for the acts of Mr. Aboudi. The issue is whether it can be any better position. If when Mr. Aboudi was acting on its behalf, he exerted, or if this had been a class 2 case, was presumed to have exerted undue influence. And so the Court of Appeal there was clearly working on the basis that if agency was made out, it would run to presumed undue influence as well as actual undue influence. And that, of course, we say is consistent with principle, because the modern approach to presumed undue influence isn't that actual and presumed undue influence are two different species, but that where presumed undue influence is made out, then that's as much a finding as undue influence as in an actual case. And that's plain from Lord Nichols in Ettridge at paragraph 16, where he says, and I won't ask you to turn it up, it's page 1678, when a plaintiff succeeds by this route, he does so because he succeeded in establishing a case of undue influence. And if that's so, and it plainly is, then it's irrational to distinguish in terms of the route by which notice is given or rather the route by which liability is attached to a third party, to distinguish between presumed and actual undue influence.
How do you establish the boundaries of this agency, Mr. Westgate? Where a solicitor is acting for, assume, I mean, it may not be the facts of this case, but where a solicitor is acting for both sides of the transaction, parties, let's call them A and B, is everything the solicitor does in relation to B being done as an agent for A, and vice versa?
I'm loath to say, but it depends.
Sure.
A great deal it's what they'll be liable for will be action within the scope of the agent's authority, and that would extend to anything so closely connected to it as to fall within that. So that's why we've referred to.
I mean, just take a classic situation where the solicitor is acting for a lender. Does it mean that any contact between the solicitor and the borrower or the owner of the property who's providing the security, following which the security is provided, means that everything that the solicitor did in his relationship with the borrower was being done as the agent for the lender?
Well, not necessarily, and it's the point that arose in Ettridge,
Yes.
By reference to section 199 of the Law of Property Act. In that case, because and there's a corresponding provision in the Trinidad legislation that the bank isn't affected by notice unless it's got actual notice, or its notice coming to its agent acting as such. And the way round this problem that was adopted in Ettridge was to say that it's possible for the bank to require the solicitor to act for the borrower or act for the surety in giving her advice, but for that not to be acting for the bank. And indeed,
Well, if that's right, how is it that nonetheless, if a solicitor isn't asked by the bank to give the lender or to give the borrower advice, nonetheless, if he exercises undue influence over the borrower, he's acting as agent for the bank?
Because in this case, he was only acting for the bank. And so it was an express part of the bank's case when they were dealing with an argument that there was a conflict, that couldn't be the case because there was no relationship with Dankou and he was only acting for the bank.
But doesn't the presumption of his influence over Mr Dankou or Nature Resorts arise from the very fact that he is their solicitor?
Well, it arises from the fact that he was their solicitor in a different...
Well, wait a minute, because the Court of Appeal overturned Mr Justice Pemberton's decision that because it was in the past, then the current transaction wasn't tainted. And I thought it was your case that the solicitor relationship continued right through this whole period. You seem to be you seem to be saying that although the presumption of influence arises from the attorney-client relationship, that he wasn't actually acting as Nature Resorts attorney in this transaction. He was acting for the bank solely in this transaction. So he sort of gets the worst of both worlds.
In one sense he does, but the reason for that is that whether you say that the relationship of solicitor continued, or whether you say that the influence arising from that relationship continues, perhaps doesn't make much difference. And in this case, it's perhaps a little unrealistic to say it's just the influence when it's all still happening on the same day. But the clear findings of the judge were that although Wheeler was acting for the company and for Dankou in relation to the share purchase parts of the arrangement, he wasn't acting for them in respect to the mortgage.
But he was a director of the company.
He was, but in his capacity as solicitor, he wasn't acting for, he was only acting for the bank. Now that may have put him in some position of difficulty as a director, whether as a director he could properly sanction an agreement of this kind. But that's that's not the basis on which the case was put.
But I'm still struggling with this idea that you rely on the irrebuttable presumption of influence arising from the attorney-client relationship between Mr. Wheeler and Nature Resorts stroke Mr. Dankou on the one hand to get your case off the ground. But on the other hand, you say that in the transaction he was acting only Mr. Wheeler. But so how can the presumption of influence then adhere if he's
it's partly for those sort of reasons that we say that the context here is very different from one where you have a solicitor acting on an execution only administrative basis for borrower and lender, where we would accept that a presumption there wouldn't have. But what one has here is a situation where a professional relationship in respect of what I can perhaps call the share transactions that has happened up to and including 28th of March. In that respect, the Wheeler is acting for Dankou. On the same day, you've got the mortgage relationship where, as a matter of retainer, only Wheeler only acts for the bank. Nobody explains that to Mr. Dankou in the course of the meeting, and that's why I said that there's a level of looseness about who's giving advice for what purposes. It's because of that set of arrangements, because of the timing, and because of the way in which the transactions happened, and because of the way they were explained, and because of the lack of explanation, that we say that this is a case where it's right to say that this is a particular arrangement where one can certainly see the operation of influence, or at least the potential for the operation of influence. Now, the legal mechanism by which we seek to achieve that is, you're right, the presumption of influence arising from the earlier relationship, or the relationship in respect to the share transactions. But the reason why that still runs in respect of the mortgage is that the trust placed in Wheeler doesn't disappear when the shareholders agreement is signed.
But would that trust have disappeared if Mr. Wheeler had said, "You need to bear in mind, Mr. Dankou, that as regards the mortgage, I'm really just acting for the bank"?
We wouldn't want to say that it would necessarily have done, but it might have done, and that may be an explanation as to why the kind of point I'm raising doesn't arise in the Ettridge kind of case. Because of course one of the problems we identify in our case is that if we're right, well, where do you draw the line in cases like Ettridge, where someone is expressly brought in to advise the wife while at the same time acting for the bank? And it may well be that the degree of openness that was required in Ettridge, where everyone goes into it with their eyes open, where the solicitor is required expressly to explain that they're there in order to counter undue influence, and that the bank may rely on what they say, that sort of thing may well dispel the presumption. But there's nothing like that here.
I mean, Mr. Westgate, isn't there a problem in what you're submitting, because you are relying on the so-called irrebuttable presumption of influence by a solicitor over its client? Now, for that irrebuttable presumption of influence to apply, you really need the solicitor to be a solicitor in relation to the transaction with which we're concerned. Because otherwise, aren't you then turning to there not being an irrebuttable presumption of influence, but a building up of influence on the facts because of a prior relationship that factually has continued, and one can therefore establish on the facts rather than by reason of a rebuttable presumption that the influence, the degree of influence, is continuing even in relation to this transaction. But that's not how your case has been put.
Well, my lord, that is why when I dealt with this earlier, I said that the natural place for this point to be addressed is at the stage of rebuttal. And so it's entirely consistent to say, well, there's an irrebuttable presumption that this is a relationship of influence. But when you come to look at what happened in the transaction, the influence didn't, that influence didn't play a part in this transaction because it was dispelled by what else was said and the circumstances. And it may be that's a cleaner way of dealing with it. And although it might appear then to open up the prospect of cases being run on the basis that you have, you get over the first two hurdles and then the burden shifts. In a clear case, it's something where the court could no doubt deal with it more summarily.
But it does make, it does create a risk of a lot of commercial transactions being thrown into uncertainty if the threat of the person who thinks they've got a bad deal is, well, this is such a bad deal and it's going to be for you to explain to the court why this should not be set aside. I mean, there are risks in a commercial context for everything being thrown on the factual assessment of the court as to whether a sufficient explanation has been put forward in terms of the negotiating stances of parties who have decided that one of them doesn't like the agreement that they entered into. It means that they can't now stand on the terms of the agreement. It's all thrown into uncertainty because it depends on what the court makes of whether the sufficient explanation has been given.
Well, in the context of this particular transaction, one answer to that would have been to go to somebody else on the list. The bank didn't have to choose Lex Caribbean, who happened to be acting for the shareholders, and if they'd not done that, then none of this problem would have arisen. And so it's something which is in the hands of the parties who appoint their solicitors as agents, and you know, any solicitor will know what the position is on the ordinary conflict checks they do, and it's fairly simple questions that can be put to solicitors to avoid that risk. Now,
well, it's not a conflict with them. The conflict is that Mr. Wheeler is also Nature Resorts attorney, but I thought that your case was specifically that you don't have to show that the bank knew that Mr. Wheeler was also the attorney. I thought your case was because it's a true agency, it doesn't matter whether they knew or not that Mr. Wheeler also had this relationship with Nature Resorts.
but so far as imposing liability is concerned, that's right. But so far as the ability of commercial parties to protect themselves, it's relatively easy for someone appointing a solicitor or agent to say, well, do you have any professional relationship with the other party of this transaction? If not, if you do, then I'll go to somebody else on our list.
I hesitate to intervene, but we are 4 minutes over Mr. Westgate's original time allocation. I'm minded to extend it to 22 because we made a 10-minute late start.
Can I in that case spend my last 7 minutes on the section 56?
Well, that's what I was going to invite you to do,
Yes.
Mr. Westgate. And in particular, because we've read what you've had to say in writing about it, and indeed what your opponent has to say in writing about it. But for my part, I'm particularly interested in knowing how in relation to a financial assistance statute, which is only triggered if a certain factual situation exists, namely, is it prejudice to the company or disadvantage to the company?
It's circumstances prejudicial to.
Yes, prejudicial, but that's a factual question as much as anything else. And this case not having been, as I understand it, advanced either at first instance or before the Court of Appeal, you have the sort of basic materials with which to advance it now. Taking fully on board the point that there are occasions when, if there's an illegality staring the court in the face, it can't avoid doing something about it.
Yes, well, the question really is whether, firstly, the facts do establish circumstances prejudicial, and secondly, if they do apparently that, and this perhaps is the real point, is there any possibility of anything else that might have emerged if the matter had been fairly raised below? Have shown that that wasn't the case, because I accept that if unless I can show that it's a clear case, then the court may not be disposed to deal with it in that way.
Yeah.
So far as the circumstances prejudicial are concerned, and I don't want to take up time that we've put things in our case, but if I can ask you to go to page 1235, which is the section, and the prohibition is when circumstances prejudicial exist, and then the definition of circumstances prejudicial is in 56.2, and there are two parts to it. One is as it were, the factual conditions, which are in effect cash flow and balance sheet insolvency. But the circumstance prejudicial arises when there are reasonable grounds for believing that. So it's not necessary to prove that the company actually was insolvent in that sense. What's got to be demonstrated is that there are reasonable grounds to believe that. But what we do say is that in any case, we can go further than that, because in relation to 2B, because of the way that works, it's inevitably established once one can demonstrate that the property is charged, because the way it operates is that one has to take out of the equation any asset used to provide financial assistance, and one then has to ask what's the balance of assets, and you ask, is that less than the aggregate of the company's liability and stated capital? The stated capital, we certainly have reason to believe, is $200, because there were 200 shares, which, according to the shareholders' share sale agreement, were $1 each. And therefore, if the capital comes below $200, then 2B is made out. The capital does come below $200 because the capital is nil, because it's an asset pledged or encumbered to secure a guarantee, and so is excluded.
But you say then that you have to take out of account the whole value of the asset, even though the loan for which its security is only a small proportion of that?
Yes, because it's an all monies charge. Again, it would have been open to the bank to say, well, we're only charging the property up to the amount that we're lending, but they didn't. In relation to 2A,
I'm so sorry, can you give me the page number again? It's not coming up on my screen.
it's 1236.
236. Yeah. Yes, I got it. Thank you.
So that's 2B. In relation to 2A, company is unable or would, after giving financial assistance, be unable to pay its liabilities as they become due. Can I ask you to look at page 106 of the bundle? This is the whole host of other debts that Mrs. Justice Pemberton found were discharged by the proceeds of sale going to Mr. Dankou. And they include land tax 2004 to 2008, water rates 2005, filing of tax returns 2004, 2008, preparing annual returns 2001, 2006. It's as clear and as can be from those that for some time the company appears not to have been paying routine bills that arose simply by reason of its holding land and being a company. And so there's a clear evidence that it wasn't able to meet those from its income, because it had no income. Even if
So are these the debts of the company?
it's that's the finding of Mrs. Justice Pemberton.
Right, but if these are the debts of the company and they're being paid off with money that Mr. Dankou as shareholder got from selling his shares. So he's using his own money that he got for selling his shares qua shareholder to pay off the company's debt. Is that the situation?
Yes.
Right. Well, then doesn't that mean that the company did get a benefit?
No, we certainly think that there were some benefits, but in this sense that they arose because of Mr. Dankou's actions rather than because of the transaction, or the mortgage transaction. But obviously I'm aware that by drawing attention to this, it does make the point about it's got implications elsewhere. But for present purposes, it certainly gives reasonable grounds to think that the company was insolvent under the 56(2)(a) test. And so far as the fairness of dealing with this now, the respondent hasn't suggested, although the respondent raises it's unfair, what they singularly don't do is identify the kind of further evidence or additional evidence that might have demonstrated that the company wasn't subject to prejudicial circumstances. There's also a question about notice, which they don't deal with, we do, and I'm not going to repeat what we say in our case. I think that's 20 minutes too. I better stop.
I think so. Well, thank you very much, Mr. Westgate. We've taken you up with a lot of questions, but the question and answer process is always of great assistance. Thank you.
Thank you.
Now we'll pause for 10 minutes and resume at 10 to 3. And if necessary, but let's see how we get on, we may, Mr. Gilks, be able to give you a little extra time after 4 o'clock, but we'll see how we get on. Yes, Mr. Gilks.
Good morning, my lords and evening. Now, I think I should start by indicating that it has never been the appellant's case that Mr. Wheeler was acting for both parties. In fact, when you look at the pleadings, certainly at paragraph 21 or 25, I think it is, of the re-amended statement of case. It's on page 18 of the record. The statement appears that the mortgage was prepared by Mr. Richard Wheeler acting on behalf of the defendant. And when you go to page 21 of the record, as the defendant retained Mr. Richard Wheeler, this is page 21, paragraph 27, I and J. It says the defendant retained Mr. Richard Wheeler to act on their behalf. For the mortgage for the transaction was not in the contemplation of Mr. Dankou. Then J says that Mr. Wheeler is a partner of the firm Next Caribbean, who are retained by the first defendant for the preparation of the deeds of mortgage on behalf of their client. So I just thought I'd clear that up at the very beginning, that this has never really been part of the appellant's case, that that Mr. Wheeler was acting for him, or for the company, or for Mr. Dankou. Now, I do intend, my lords and ladies, to rest on the submissions that I have filed, and I just wish to utilize the time, with your permission, and that I've been allotted in dealing with a number of points that were raised in the appellant's case, which I don't think I spent sufficient time on when I prepared our submission. And I want to start with an assertion made at paragraph 9.2, which is on page 1147 of the bundle. And the assertion is that although Nature Resorts is bound by the finding that Richard Wheeler explained that the relevant document was a mortgage and that Culloden Estate could be sold on default of payment, there is no finding that Patrick Dankou was aware that a mortgage was to be sought on the land before the meeting took place on the 20th of March. I assume they mean 2008 or 2021. Now, in my respectful submission, my lords and ladies, this is not an accurate representation of what has taken place, because it is quite clear in my respectful submissions that both the trial judge and the Court of Appeal, agreed with the trial judge. The trial judge most certainly rejected the allegations that were based on misrepresentation. Mr. Dankou's argument was that the purpose of his visiting Mr. Wheeler's office on the morning of the 28th of March 2008 was to have him sign or execute share transfers alone. The mortgage was never part of the question. I recall in cross-examination, he was cross-examined at great length as to why then he thought he should bring his corporate secretary along if he were only going there to execute share transfers. But that was part of the narrative that he presented. And he then suggested that when he got to the meeting, again, there was a repetition of the statement that he's there to execute share transfers. He wasn't able to explain why it is he was executing, the number of documents that he was executing on the morning. Now, it's quite clear from the record that this assertion about misrepresentation was completely rejected by the trial judge. And I direct your lordships and your ladyship to pages 246 to 247 of the record, and in particular, paragraph 86 to 91 of the trial judge's decision. Now, the ladyship did spend some time suggesting that she didn't see a misrepresentation case at all. But she did make her way eventually to dealing with the allegations that had been made about what Mr. Wheeler was told was the purpose, what Mr. Dankou said he was told was the purpose of visiting the offices of Mr. Wheeler on the morning in question. And at page 246, paragraph 88, paragraph 8. Relation says, I do agree with Mr. Jokes that Patrick Dankou's account of the events leading up to the 28th of March 2008 be material at best. He recounted it in NRL's repeated case that Richard Wheeler called him at the telephone and made a specific assertion to him that the assertion, and that assertion was repeated during the course of the meeting at his office. These were supported by his witness statement. Yet in cross-examination, Mr. Dankou could not remember whether it was Richard Wheeler or his secretary who called him to request his presence in the office, and that he could not remember what was said to him. And then at paragraph 91, the trial judge states what the conclusions are in relation to those assertions. She says that I must now conclude that there was no misrepresentation by Mr. Wheeler, whether by words or by silence. FCB is not fit with liability in this instance. Well, then she goes on. 1, in answer to the question whether Richard Wheeler misrepresented to the nature resort through Patrick Dankou, the nature of the documents to be signed and executed by all of the parties in his office, more particularly the mortgage deed, I must say no. 2, in answer to the question whether it was Richard Wheeler's secretary who misrepresented the nature of the documents to be signed and executed by all of the parties in Mr. Wheeler's office, when inviting Patrick Dankou to come to his office to execute same, I must say that the evidence did not bear this out, and the answer is no. And she says, 3, since my answer to the first 2 questions is no, then I can conclude that FCB is not and cannot be fixed with liability for any misrepresentation. It was not proved to have taken place. So that in my respectful submission, it is not available to the appellant to still maintain at this stage that, there was no finding that when Mr. Dankou came to Mr. Wheeler's office on the morning of 28th of March 2008, he was laboring under some impression that he was coming to sign a mortgage, and that therefore there was some need, apart from what the explanation which the High Court and the Court of Appeal found was given to him on that morning, there was the need to displace this earlier notion that he had been told that he's coming to sign share transfers alone, and that he was told nothing about the mortgage. Now, the main difficulty that the respondent has raised with the way in which, of course, we accept that there is sufficient evidence if a presumption of undue influence does arise, that it was rebutted in particular circumstances where Mr. Wheeler explained the transaction to Mr. Dankou. But we have a great difficulty with the suggestion that a presumption of undue influence arose at all. And it's because of the route that the Court of Appeal took in arriving at that conclusion. The Court of Appeal appeared to rely on the fact that Mr. Wheeler was the bank's agent, and that because he was the bank's agent, and there was a benefit that the bank derives from the transaction, there was a presumption that this transaction called for an explanation. And what I suggested in submissions, in my written submissions, is that the court was conflating the 2 allegations that had formed the subject matter of the pleadings before the trial judge. That's the allegation of actual undue influence and the suggestion of presumed undue influence. Now, I know that the case law does suggest, or appears to suggest, that irrebuttably there is this presumption of influence that the solicitor is likely to have over an individual for whom he is acting. It is a general statement that we've seen often in the cases that I find difficulty saying that it's not proper representation of the law. But for my part, I can anticipate circumstances in which no such presumption would arise between a solicitor and a client. If I'm a client and I have a very bad experience with my solicitor, I don't know that when I encounter him in the future, he's likely to have any positive influence over my executing the document he's putting in front of me. That influence really has to do with the fact that there's influence, as opposed to the presumption that influence exists. But I do accept that in a vast majority of cases, or at least I would like to think, in a vast majority of cases, clients are not going to have an unsatisfactory experience with their lawyers, and that there's likely to be some sort of influence the lawyer might be able to exert over the client if he encounters him in another transaction. But the question that arose here was, well, what exactly was there about this particular transaction which supposed to have given rise to this presumption of undue influence. Now, I know my learned friend has made whether, as he is entitled to, of the fact that I refer to the fact that there is no benefit to Mr. Wheeler. I'm not suggesting by any means that undue influence will only arise where there's benefit to, but that is obtained by one party to the transaction. Cases such as Willis and Barron, and it was cited to your lordship and your ladyship today, and the Bullock and Lloyd's Bank, certainly in the case of the Lloyd's Bank case. Lloyd's Bank isn't getting anything out of the transaction, and I don't think anyone would suggest that it's not possible to exert undue influence on someone, even though you're not getting something out of it. But my reference to what Mr. Wheeler was getting had to do with the question of, well, what makes this particular transaction unusual, such that it called for an explanation? On the face of it, this gentleman, Mr. Dankou, who went into Mr. Wheeler's office to execute a mortgage. That happens all the time. Trinidad and Tobago is a small jurisdiction, but we do have a lot of mortgage transactions that take place. And this is as common as grains to sand. So that on its face, there really isn't anything that stands out about this particular transaction, unless one treats it as the Court of Appeal treated it, wrongly in my respectful view, as one where the bank's agent is exerting influence over, or is presumed to have exerted influence over his former, another person with whom he has had a business relationship in the past, and perhaps still continuing up to the time of the particular transaction. He's had this relationship with him. And therefore, there's this presumption that there's some measure of influence that he has. And but in this, as regards the particular transaction, the question appears to be that you are taking execution of a mortgage which you benefit from because you are the agent of the principal and the principal benefit. And it's in that way that the Court of Appeal appears to have dealt with the question of whether or not the transaction calls for an explanation. But in my respectful submission, in every situation in which a solicitor acts for the bank derives a benefit. In every single one, what was operating as being very important in relation to this transaction is the fact that there was also a relationship between Mr. Wheeler and Mr. Dankou. And it is that itself which the Court of Appeals seems to think made the transaction one which calls for an explanation. But looking at the transaction without that knowledge, that background knowledge, there isn't anything about the transaction that is unusual. And that is what is different from all of the cases that your lordships and your ladyship have seen, have been directed to this morning and before with these submissions. In all of them, you can look at the transaction and say to yourself, well, hold on. Here is a very substantial gift being made by this young woman who has joined a religious order. And she's a wealthy woman, and she's giving all of it away, or the vast majority of it away, to a religious body. I mean, did she appreciate what she was doing? So on the face of that, the transaction calls for an explanation, because that is the protective aspect of what the law brings to bear in circumstances where the transaction is unusual. But when it comes to a transaction like this, there really isn't anything that is unusual about it at all. Now, what the learned friend has attempted to do at paragraph 23 of his submission is to point out a number of things which he says makes the transaction unusual and one that calls for an explanation. I'll direct you in particular to paragraph 23.3, which appears on page 1155 of the bundle. Now, at 23.1, the statement appears that the security taken by NRL went beyond what was necessary because it was an all money charge. And nature resource therefore had no protection against the value of the estate being eroded by further borrowing. Now, I'm very reluctant to say too much on the bar table about how transactions of this nature take place in Trinidad and Tobago. But if you permit me to say, the clause is by no means remarkable. Most mortgages contain this type of clause, largely because the banks appear to hedge on the basis that, you may then want to have further borrowings and that sort of thing. So they frame it in a sort of very general way. You are guaranteeing all borrowings and that sort of thing. But what the bank did in this case was to calculate the interest in advance and to add it on to the principal amount that was being lent and to stamp the mortgage to cover the principal and the interest. So that although there was this very broad clause, in reality, what the nature resource had given was a very limited security. It was limited to the amount of the loan and the interest calculated in front. Just added on, and then the mortgage stamped to cover that amount.
Could you show us how that comes about, please?
There are a
Or at
number
least just refer to the what clause in the mortgage deed you say has that effect.
Yes, now the mortgage clause, I think this morning we sent along a clearer copy, because on that copy there's this stamp, or there's a stamp indicating what the stamp duty charge was at the top left of the document. And the all monies clause appears on page 2 of that document. It's paragraph 1, numbered 1. The borrower hereby covenants with the lender that he will on demand in writing made to him pay to the lender the balance which on the account of the borrower with the lender shall for the time being, and whether on or at any time after such demand be due and owing. So it's really limited to whatever it is on the account of the borrower with the lender. But then there is the limitation of it being, it's limited to the amount, because the mortgage instructions which were given, which can be found at page 106 of the bundle, indicate that the mortgage is to be stamped for just the $2.3 million US.
That may be, but that point may be as a result of the taxing provisions in Trinidad and Tobago, that if you have an all monies charge, you simply take the amount being agreed to be advanced at the outset. It doesn't really tell us very much.
No, but what tends to happen is that it doesn't happen that the bank simply picks up and increases the stamp duty on the mortgage and then simply says, well, I'm going to lend more to the borrower. There has to be an agreement between the borrower and the bank, and of course then between the surety and the bank, that the bank is going to provide that additional security. And of course, if the security is changed without the knowledge of the bank, also of the security giver, that by itself discharges the security.
Well, but is this point going to section 56?
No, it's not.
Okay.
I'm simply dealing with, well, at least not directly, I'm simply dealing with what my learned friend has suggested made this transaction unusual. And he was suggesting the all money clause is something that made it unusual.
Because the NRL would have no control over what further agreement for the lending of money might be come to between the borrower and the bank.
Yes.
It doesn't.
Yes. Yes.
So that's why it's disadvantageous. It's prejudicial.
But I'm saying it's not unusual because it happens almost all the time.
That doesn't stop it being disadvantageous in these circumstances. That's simply saying, well, all money's charges are regular. Well, we think we probably know that on the part of the bar.
That I would agree with my lady, that it certainly can be disadvantageous to a customer, but in practice it is not, because certainly my understanding of the law is that if for any reason the bank were to increase lending to the borrower, and were to seek to bring that home to the surety, this would constitute a change in the conditions of the surety had agreed, and it would discharge the security.
Well, it might do, but NRL was not the customer. The customer was the borrower.
Of course, but
So
in giving the security, if anything were changed to the disadvantage of NRL, that would discharge the security entirely.
that depends on the terms of the charge and the terms of the guarantee. If it's a guarantee in the normal bank form, the surety will not be released by further advances by the bank. Anyway, it's neither here nor there. This is not a point about section 56, I understand.
No, it's not. I'm merely dealing with the question of whether one should have seen this clause and said, hang on, what's going on here? Which is what I thought my learned friend was getting at when he referenced it. And the other thing is that at paragraph 23.3.2, he talks about NRL also secured the sums held back by Taylor and James out of the loan proceeds. This is the amount of $425,000. Now, I think what he is referring to here is that the bank released the loan proceeds in the sum of 1.925 million. But all you have being dealt with on the face of the evidence is 1.5 million. Now, I don't think it is correct to say that anything was held back by Taylor and James, because Taylor and James never were in control of the proceeds of the sale. The proceeds of sale were released to Mr. Wheeler, and Mr. Wheeler acted at all times on the instructions of Mr. Dankou. Now, he received instructions on the 1st of April 2008 as to how to deal with the 1.5 million of the proceeds of sale. We do not have evidence as to how the other 425,000 was dealt with. But certainly, what we do know is that only the 1.5 million was applied to the purchase price of the shares. So that when the share purchase agreement had been signed, a 10% deposit was then made. You then had 1.275 million was in US dollars was paid at that point. You then had 1.5 million of the proceeds of the loan going towards the purchase price of the shares. And then Taylor and James signed a promissory note for the difference of 975,000 US dollars. So that you have this odd incident of Taylor and James obtaining this loan for 1.925 million. but allowing $425,000 to remain in abeyance somewhere with only 1.5 million going towards the purchase price of the shares. So they now still owe 975 million US, 975,000 US dollars. So it's an unusual arrangement. We did not bring out in evidence why that arrangement was made in that way, but it's an arrangement which certainly benefited Nature Resorts and Mr. Dankou. And it certainly is not evidence of something unusual about the mortgage transaction, because all of this is taking place in terms of how the money is disbursed. It's taking place after the mortgage transaction. So it's not apparent how one could look at how Dankou is allowed by Taylor and James to use the proceeds of the loan. Say, well, hey, this is a transaction which suggests that we need to have something explained because there may be some oppression being exerted on Mr. Dankou. If anything, it seems that Mr. Dankou is leading Mr. Taylor and Mr. James around by the nose, and not the other way around. So it doesn't seem to me, my lords and ladies, that Melinda Friend can rely on anything that is said here about the transaction being unusual to suggest that it was unusual. There's nothing here that suggests that the transaction was one that called for an explanation. And it's that reason that I say that we come back now to, well, what exactly did the Court of Appeal consider was unusual about the transaction? It does appear as if the Court of Appeal seemed to think that once you have an attorney-client relationship that exists between two parties, there's a presumption of undue influence. So that anything that comes out of the relationship calls for an explanation. That's what it appears. Now, what did they say in explaining the conclusions they reached? And it's why we dealt with the question of we sort of put two questions together. The question of how is the bank being affected by all of this? Because we have no notice, and the presumption of undue influence. We deal with it together because, in my respectful view, the Court of Appeal dealt with the two things together. They appear to have looked at the fact that Mr. Wheeler was the agent of his citizen, and that therefore, and that he had a relationship, an attorney-client relationship with Mr. Dankou. They've put all of that together and come to the conclusion that because of the relationship between Wheeler and Dankou, there's an attorney-client relationship and a presumption of undue influence, or at least a presumption of influence. And then the transaction calls for an explanation because when you look at it, because of the agency that existed between Wheeler and the bank received the benefit. And it's like if Wheeler got the benefit, and therefore it calls for explanation. And my respectful submission, the logic that was applied, my respectful submission, is not one that can be sustained. In terms of how a presumption of undue influence could arise. And that takes the next point. The transaction called for an explanation. But then how is the bank being affected by it? I mean, Trinidad and Tobago is by itself a small country. Tobago has 55,000 people. It's a very small community. So you have a situation where a lot of people can know a lot of people. The bank, without actually knowing that there was an attorney-client relationship existing between its lawyer. Now, Lex Caribbean is the only large law firm on the island of Tobago. They're a large law firm in Trinidad, they're a large law firm in Jamaica and in Barbados, but they have a presence in Tobago. But they're the only large legal presence in the island. So that it stands to reason the bank based in Tobago would be utilizing Lex Caribbean. And the persons coming to the island not knowing anything else not knowing the landscape, are likely to find their way to Lex Caribbean. If you Google anything, you would see Lex Caribbean. That's where you'd go. So it's very likely, especially an expat. You come to the island, you don't know anybody. What are you going to do? You're going to do a search and you're going to see Lex Caribbean, you're going to go there. You're saying that because Mr. Dankou found his way to Lex Caribbean to do his, for the formation of his company and the initial business transactions that he did, which is half of the business community in Trinidad and Tobago. Because of that fact, and that fact alone makes it apparent that you can have many such situations in which the person is then seeking to do business with the bank, and it's the person that you've dealt with in the past. The bank does not know that there was such a relationship between you and in the past. But the bank is then fixed with knowledge because its agent had a relationship with this other person that you're dealing with. And by virtue of the agency, I am deemed to be in the same attorney-client relationship with the person as the lawyer was. And it just seems, my lords and ladies, it's absurd to apply agency as a means of bringing home to the bank knowledge or notice of a relationship. I can fully understand the bank must take responsibility for the actions of its agent. And it's the reason why I make the point in the submissions about, I can see very clearly with actual undue influence. But when it comes to presumed undue influence, and it's derived from a relationship that exists that I could know nothing about, and that could very easily exist in a small community, how do I know that I need to get protection by asking the person to get independent legal advice? How would I ever know that? It's a lotto. It's all tossed up in the air, and it could be anybody's game. And anyone can say, well, you know, I had a relationship with this person. It could have been how many years ago. I could have I have drinks every evening, as indeed Mr. Dankou sort of suggests. And therefore, there's a very close relationship between us. It turns out that this person is your agent, and therefore, you're liable for the presumption of undue influence as sitting over me, even though you don't know anything about the relationship. Now, we sought in the Court of Appeal to point their lordship to Etheridge, not for the similarity in fact, but for the proposition that when you're talking about a presumption of undue influence, what their lordships in that case were attempting to do was to find some simple way by which the bank would know it needs to protect itself. So there's obviously the desire to protect persons who may find themselves in Miss Alcard's position in Alcard's skin. So there's obviously that need of court to protect people. But at the same time, there's also the need, which was very much the point of Etheridge. Well, how does a bank continue to still do business with people without the worry that my transaction could be set aside at any moment? And the mechanism is noticed. Because in my respectful submission, it is unreasonable to use agency when it comes to presumptions. It's time to use it in relation to action. But when it comes to presumptions can arise from relationships. It can be very subtle. And there's very little that a bank can do to protect itself. So it's either you or you tell your lawyers you can't deal with anybody but us. So you are the first citizen's law firm. Or you run the risk with every transaction that the person you're dealing with may have had a relationship with one of the customers that is coming through your doors. And to my respectful submission, that simply is not workable. But yet, that is the way in which notice was brought home to the bank in this case. Now, Melinda Fred has suggested that the bank would have known of Wheeler's relationship with Dankou because Wheeler signed the share purchase agreement. But the thing is, he signed it. There's no preparation clause. There's nothing that refers to the expiration or his name. So that you're expecting the bank to see the document, know that this is Wheeler's signature, and then to derive knowledge from that fact alone. And in my respectful submission, that's simply not fair. My mind, in this case, if it is in which the transaction did call for an explanation, then it must be that the bank is aware of the circumstances which caused it to call for an explanation, and therefore to protect itself by looking to direct the person towards independent legal advice. In fact, the practice very much in this country is that once house is giving security, she doesn't get to come through the bank's doors at all unless working with an ILA, an independent legal advice that she would have obtained even before she comes to sit down and say, yes, I'm prepared to help my husband with his loan, la-di-da-di-da-di-da-di-da. Whether it is she's also acquiring the property, it's standard practice. You go to a lawyer, you get the person to explain the transaction to you. The lawyer needs to prepare this document, and you've got to sign it saying you understand it. We know who it's prepared by. The lawyer often gets a call from the bank's lawyer saying, did you prepare this document, that sort of thing. And that has been the reaction to O'Brien. But I don't know what I'm supposed to tell the bank. Circumstances like this, where your lawyer could have a relationship with somebody. I mean, the situation can happen not only in relation to lawyers. It could be that the bank hires a valuator to guide it in relation to the particular transaction. I can say there aren't many valuators on the island of Tobago. Everybody tends to go to one, or you bring somebody from Trinidad if you feel that you're going to be in a conflict situation. So you go to your valuator. He doesn't manage to tell you, but I know Mr Dankou, and I know her very well, and we have tea together all the time, and she's like, I'm her confidant, and blah, 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 blah. And it becomes apparent that there's this very close relationship between the bank doesn't know that. But of course, the valuator is the bank's agent. It could be a surveyor hired for the particular purposes relating to a particular conveyancing transaction. There can be countless ways in which a person the bank can find itself in a situation where I have to act through agents, carry on my day-to-day business. Those agents have lives, they interact with people, and I really have no protection whatsoever if it turns out that the agent has some sort of relationship with my customer, or the person who is coming to my door to provide security. But in my respectful view, I mean, it's dangerous, in my view, to move away from what Etheridge was trying to establish, which is notice. None of the cases that my learned friend has cited are cases of presumed undue influence. When you look at Abudi, it's actual undue influence. Even the cases that were cited this morning, they are actual undue influence cases. There isn't a case apart from this one, and subject to what your lordship and your ladyship may do today, that establishes the question for an agent bringing home to a principal knowledge by agency of a presumption of influence exerted by him on somebody else. This is the first time from what I can see. I can't claim that I have exhausted the entire common law or the entire Commonwealth cases, but I haven't found any but this one where the court did that. And I urge your lordship and your leadership to not to set this question in this case. So, in relation,
Mr. Gill, can I just ask you? I think it's been put against you on that point that, as a matter of principle, and one might say Etheridge clearly established this, there is only one underlying concept, and that's undue influence. It may be provable in one of two ways, either by evidence of actual undue influence or by presumption, but there's only one underlying concept, and that's undue influence. Wouldn't it therefore be rather surprising if, when it comes to the question of whether third parties are affected, there would be some difference as to whether agency applies, whether you're dealing with one method of proof or not?
Well, I think my lord, I wouldn't think it is surprising at all, because at the end of the day, the question is, well, what is the court trying to accomplish by setting any particular test? So that I can understand in Ettridge why the court struggled with O'Brien and then with Ettridge, for setting a simple mechanism. You want to be fair to all sides. So you want people to continue to be able to do business, but you want to protect people who have been disadvantaged. So the question really is, well, what is the principle you are asking a party to abide by? What are you expecting that party to be guided by? Is to do what? At the end of the day, banks want to do business. They want to grant loans. They want to take security for loans. They want to do those things. That's what they do. People want to be able to leverage their assets and to be able to go to the bank and to use them. And bank is to be told, well, you know, this could be entirely up in the air, you know, when it comes to undue influence, because this could pop up from anywhere, and you don't have to know about it. If it turns out that it arises from a relationship that someone of your employees or your external agents uses, so it arises from circumstance involving one of your agents, you can have a problem enforcing security. Then the question is really, what is the purpose of the proposition? The law is not, I don't mean to lecture anyone, but the law has always been there to organize, whether if it's a commercial law, to ensure that business people can operate and people are protected while they're operating. That's what it is, and it's to facilitate a particular kind of environment. And the question is, well, what is the utility of this proposition that, you know, without any notice, actual notice, or any means of putting yourself on notice of wrongdoing, you could have security undermined, or you could be deprived of business that you would have tried to underwrite otherwise. Other than what other objective would you have other than to stifle or to snuff out that kind of business? As it is, it's hard enough for small individuals coming to banks to get loans and to have their property access to the security. And that was one of the concerns in the United Kingdom with Ettridge. I mean, do you want to protect wives or spouses generally, because it's not only wives who will be in that situation, but you want to protect spouses and the matrimonial home. But very often that's the asset that's most valuable to you that you wish to leverage. So it's a question of putting a fair arrangement in place that works for everyone. You ensure that on the Alcard side, there's no advantage being taken of a vulnerable person. But on the Royal Bank of Scotland side, you're making sure that they can still do business. And to my mind, that is the balance that needs to be struck, if I may respectfully say so, and which can be struck in this case by treating with the issues in the way in which we are suggesting. Now, my lords, the only other thing I wish to touch on was really in relation to Section 56.
Yes, please.
And the thing is, I thought that what I thought to do was to set out as clearly as possible what I thought were the differences between the legislative regime in Trinidad and Tobago, when as compared to what it is in Canada. And I'm particularly concerned about that juxtaposition because much of our company legislation is borrowed from Canada. But in this particular regard, it's very different in that there is no prohibition on a company granting loans to assist a party to purchase shares in the company. There's no such prohibition. The only time this becomes an issue is if you are going to affect the ability of creditors to be paid in the event of an insolvency. But that is the way in which the legislation is set up. So on its face, there is nothing that was wrong. And I think the Court of Appeal made the point in the course of its judgment that there's no law that prevents, but it wasn't as blanket as that. That he said, I think the court said there's no law that prevents a company from assisting a shareholder to acquire shares. But there is a law. If there is an insolvency, well, or you would result in insolvency, well, then yes, it does prevent you. But it really it is the burden of the person seeking to say that it will result in insolvency to come and speak. And therefore, the pleadings of that assertion are extremely important. It wasn't so in the Republic Bank and Royal Bank and Stewart, because the regime there creates a prohibition against doing it. So the Royal Bank needed to come to court and to adduce some evidence that demonstrated how it was falling within one of the exceptions. And that's why the judge had the judge struggled the way he did. He said, I'm looking to see what evidence there is. And I'm not seeing very much evidence of this. I'm not seeing very much evidence of that. In fact, the evidence appears to point a certain way and that sort of thing. But he needed to make a positive finding that this is a transaction that could take place. That is not what needs probably your lordship and your leadership here. On the face of it, this is a transaction that is perfectly allowed. And the only question is really whether, I wouldn't say it's a question, because the fact is it was not raised in the court below. And therefore, it can't just be sprung on the bank. Well, there may have been this or there may have been that. I mean, what we have is Justice Pemberton saying, well, look, it seems that a lot of the money went towards paying the company's debt. But even that, I mean, which means that the company has no debts at this point, they've been paid. Or no, they don't have those debts. I don't know if they have new ones. But the thing is, I don't know, he didn't spend any time on it at the trial because it wasn't raised. But the fact is that the money was being applied to cover land taxes and that sort of thing, it may have been to reimburse someone for the payment of those things. I don't know that the land taxes had remained unpaid from 2001 to 2008, or that the surveyors and the persons that performed the valuations and the various different services for the company had remained unpaid in all of those years, and they were suddenly being paid out of the proceeds of sale of the shares. This is how Mr. Dankou asked for the funds to be allocated, and it appears it could easily have been that he was talking about reimbursement. I don't think he cut to the Board of Inland Revenue or to the District Revenue Office for land taxes. There's no evidence of that. But even if there were, what does it say about the solvency of the company? The test you've got to apply is you look at the realizable value of the property, and then you take out of that what you've pledged. You don't discard the property altogether. You look at what its realizable value is.
Could you take us to the provision, because this is an exercise of statutory interpretation, And we
Yes.
must do it not against propositions about it's up to the creditors to show that the company was insolvent, but against the legislature, which we must take it has set out exactly what it wants.
Yes, bear with me. I know that Melinda Friend referred to it only a short while ago. As we're in the record.
It's at 1235.
Yes, thank you so much. Yes, so we have section 56 at the bottom of 1235, which says, when circumstances prejudicial to the company exist, the company or any company with which it is affiliated shall not directly or indirectly give financial assistance by means of a loan, guarantee, or otherwise to a shareholder, director, officer, or employee, or affiliated company, or to an associate of any such person for any purpose, or to any person for the purpose of or in connection with the purchase of a share issued or to be issued by the company. And then it goes on to define at 56 on page 1236 what circumstances prejudicial to the company mean. So it means those circumstances exist.
With respect, it doesn't say mean, but we can take it as mean for the moment.
Yes.
What it's saying is the following certainly qualify as circumstances prejudicial to the company.
Yes.
For the purposes of the legislative provision.
Yes. And it cites these situations. A, the company is unable or would, after giving the financial assistance, be unable to pay its liabilities as they become due. And then it goes on to say, or B, the realizable value of the company's assets, excluding the amount of any financial assistance in the form of a loan and in the form of assets pledged or encumbered secure guarantee, would, after giving the financial assistance, be less than the aggregate of the company's liabilities and stated capital of all classes. Now, we don't know what liabilities the company had at the time. We know that the stated capital appears to have been $200. We know that we don't know exactly what the realizable value would have been, but we do have valuations that put the value of the property way in excess of what was pledged in terms of the financial assistance. So on the face of this, there really isn't anything that indicates that there was any threat of there being circumstances prejudicial to the company existing.
But the test under 56(2)(b) is not, it would be said, the question of whether or not assets exceeded liabilities and whether there was absolute insolvency, but whether or not the amount charged exceeded the liabilities. The amount of the assets charged would exceed the amount of the liabilities. So what is being said against you is the amount of the assets were actually all its material assets, and that they must necessarily have exceeded liabilities and stated capital.
Well, how I read it, Melody, is that in B, we start with the realizable value of the company's asset. Then you exclude, let us say that $7.4 million because that's the value that they were working with at the time of the loan. And then you exclude the amount of the financial assistance, that's $2.75 million. If you round it up to 3, you still have in excess of $4 million. And then and then you look to see whether the that sum is less than the stated capital. So would the shareholders get back what they put in acquiring their shares, and the aggregate of that with the company's debts and liabilities, which we don't know anything about.
Yes, I understand how you put it, but what meaning do you give to the words after financial assistance, which you didn't read, in the form of a loan or in the form of assets pledged or encumbered to secure a guarantee? So
Well,
to identify the assets.
I wouldn't read it any differently, because I think what it is suggesting is, you know, the realizable assets, the realizable value would be what you would get when you sell it. But of course, you have to deduct, because the first claim on that sum would be the security. So you have the realizable value. The realizable value would have to be the net of what you could get for it after you deduct what the security. So that's how I read the after. That the realizable value you're speaking about is this sum that you would get after you have paid off the secured creditors. This is what you're left with. And is that
Sorry.
Sorry.
No, I'm very sorry. Please finish your sentence. I thought you'd finished.
Yes, and is that sum less than the aggregate of the company's debts and the stated capital? Because it's in those circumstances, it being my view that the purpose of these provisions is to ensure that companies don't go off granting loans and giving security and doing all sorts of things. And then when push comes to shove, you can't pay your bills. And if you would end up in a liquidation, the shareholders are out of pocket.
Yes, because this sort of financial assistance is really for helping shareholders or purchasers of shares. But you mentioned a moment ago that it's very usual to have an all monies transaction. And it may not be that the legislator was aware of that problem, but somebody may just give a charge on an all monies basis, just borrow a small amount, but leave it open for there to be a much bigger amount added to the charge so that all the assets were consumed. And for that reason, might it not be that the legislature required the deduction or exclusion not just of the amount actually borrowed on the occasion, but the amount of any financial assistance in the form of assets pledged? So that would cover your all money situation. You would have to go look. It would help to address the mischief of having an all monies charge by requiring the company to look at the total amount pledged or encumbered to secure the guarantee.
Well, I don't think that the intention of the legislature was to create a situation where if a company has only one asset, it can't grant a loan at all, because that would be the consequence of reading it that way. It would, because if you have to exclude the asset once it is pledged, then basically you're saying you could never do it. And I don't know that that is what was intended. Even with the all monies clause, if you're going to increase the borrowing, at that point in time, that increased borrowing will be subject to this liquidity test. It's at that point it becomes subject to it. It wouldn't be that you have a liquidity test that you apply for all time. So, I'm sorry.
But two points there. One is the only place we can find the intention of the legislature is in the words that the legislature has used.
Yes.
And second, you test whether or not there are circumstances prejudicial to the company, whether they exist at the time when the company actually gives the financial assistance. Yes. So that's when it executes the charge. Well, in this case, on an all monies basis and charging the effective entirety of its undertaking and assets. So I'm just going to make those 2 points in response. It may seem very hard on the facts of this case, of course, but if the wording that the legislature has used is the amount of the assistance in the form of assets pledged, can you help me? What are we directed not to the amount which is actually being pledged? The realizable value of the amount of assets actually pledged, not the amount actually borrowed at stage 1?
Well, I wouldn't have thought that there's any practical utility in construing legislation in that way, because at the end of the day, I don't think it was the intention of the legislature to simply bar a company with one major asset from leveraging the asset, because the provision is not confined to only the situation where you're talking about purchasing shares. You're also talking about giving any kind of assistance to a shareholder, director, employee. So I don't think that the objective of the legislation was to say you are to take the asset out of circulation altogether, out of the calculation altogether. So you need to have several assets before you can talk about granting any kind of assistance. Because once you grant any assistance and you have the asset pledged in some way, well, then you become illiquid. And that would be the consequence of reading it in that way, in my respectful submission. I think it is far more useful for the provision to be understood as when you're talking about the realizable value of the asset, which is what you would get on sale of it, after you take into account what is pledged. Because, as I said, the all money's clause, if it is that you are talking about granting further lending on the security of this asset, there will then be the need for a fresh agreement and the of stamping of the security. At that point in time, the liquidity test will have to be applied again.
So I think what you're saying that if you do have to deduct the whole value of the asset that's pledged, then because of the breadth of 56(1)(a), if you had 2 directors of a company and only 1 asset, you could only ever make a loan to one of them if the loan included an all monies clause, because then the asset would have been pledged entirely up to its full value for a loan, even if it was only a small loan to one director. That would be it. The company couldn't make another loan to any of those people listed in 56(1)(a) for any purpose.
But I'm saying more than that, Milady. I'm saying that you couldn't even make a loan to that director, because that would put you in an illiquid situation, applying the calculation that was suggested by my learned friend, where you take the asset entirely out of the picture because it has been pledged. Immediately, the company has become illiquid because what is left is insufficient to pay its debt and to cover the capital, so that you couldn't make any loan at all once you have a single asset.
Well, with respect, you said, I'm sorry, with respect, you have made the point that, well, if any further money was wanted, there'd have to be a fresh agreement. But if the guarantor has executed a bank guarantee in normal form required by banks, it will have given either an unlimited guarantee or a guarantee up to a fixed amount. And then the borrower could keep on incurring liabilities up to that amount or on an unlimited basis. So there is if that's what is wanted, then what the legislature may be saying is that's a prohibited transaction, because
but it's a big if, Melody, because that is not how the clause is formulated in this case, because there is the limit of what it is stamped to cover, and there is also the limit of what the underlying borrowing was. If it is that the borrower comes back to the bank and says, I want more money, I do not think it follows that because there's an all monies clause in the mortgage, that the bank is free to utilize the mortgage as security for that additional lending. It has to come back to the guarantor, because it would seem to me the failure to come back to the guarantor would be to change the terms upon which the guarantor agreed to give the guarantee in the first place. and that ought to discharge the guarantee.
Do we have the guarantee? I'm so sorry, I should know that.
Well, the security, it ought to discharge it.
Thank you. Thank you very much. Thank you.
Much obliged, lady.
Now,
Unless there's anything else.
thank you very much, Mr. Jokes. I think you've been of great assistance in answering our questions as well. We ought to give a short time. Oh, I can see we have one further question to come from Lord Burrows. Lord Burrows, do you have a question? Your hand was up.
Yes, sorry, I was unmuted. I beg your pardon. Is there any assistance you can gain from section 57? I mean, might it be said that in these circumstances, the lender is for value in good faith without notice of the contravention?
Yes, I forgot to say that, but I did say it in the written submissions that certainly in these circumstances, even if the bank could certainly say we were not aware that anything that was being done here would have constituted the contravention of section 56, and it is differently worded to the provision cited in Stewart, because in that case you're talking about a situation where the thing is banned, so you had to have you had to have notice. If you talk about a bona fide purchase without notice, the bank couldn't say that I didn't know that this was a transaction for the purchase of shares. In this case, we are talking about not because giving assistance to purchase shares is fine. What you have to know and have notice of is the contravention of liquidity provision or the liquidity situation. You have to have some knowledge that circumstances prejudicial to the company existed at the time when the loan granted. That's the contravention we are concerned with here. I'm very grateful to my Lord for reminding me of that. It would seem to me that the bank shouldn't be entitled to say, well, but how did I know this?
Thank you, Mr. Jokes. We better give Mr. Westgate a few minutes to reply. I think, will 10 minutes be sufficient, Mr. Westgate?
Sorry, can you hear me? Yeah, yes, it will be.
Thank you.
Yes. Can I start with the section 56 point? Just 2 points on that. The respondents have really focused on, or the arguments really focused on 56(2)(b. There doesn't appear to be any dispute that if the company could indeed not pay its liabilities as they became due, and if that was properly evidenced by the letter of the 1st of April 2008, then 2A would be made out. The suggestion was made that there might have been other explanations as to why the payments couldn't have been made, or that they were reimbursements of sums advanced or something of that kind. But that is unrealistic when you look at the list of items in that letter.
Well, excuse me, was that a letter known to the bank?
Yes, no, well, not at the time, no, because that's the letter of instruction after the advance was made.
Yes, thank you.
In relation to notice, we deal with that in our case, and given the time, I won't ask you to go through that, but I will make a couple of points about section 57. In relation to section 57, in relation to 2B, the effect of the respondents' arguments is that, in effect, they give no meaning to the words excluding to guarantee, because the thrust of the respondents' argument was always that the answer will be the same whether you apply those words or if you simply ask the question, what is the realizable value of the company's asset? Yeah. Because their argument was at any time you simply deduct what's owing and that gives you the realizable value, or that gives you the aggregate of the value, whereas those words must add something. I'm not going to. I'm focusing on reply here rather than repeating what we say in our case. But in relation to 57, we have really 3 points. One is, or the first two really are to do with the construction of 57, because it only provides that a contract can be enforced by the company or by a lender for value. And that can't mean that a lender can enforce any contract they happen to make, because that would put a lender in an irrationally privileged position as against other parties. So lender there must mean, or the contract that they can enforce must mean their loan contract rather than some ancillary contract. So therefore they can get their money back if they lend it, but what it doesn't do is extend to a mortgage. I accept that that's an argument which hasn't been advanced for reasons I know not in the Canadian cases to which you're referred, but an argument that has been advanced there and accepted in the XDG case is that even if the mortgage falls within this, it's not a mortgage for value, or at least not in this context, because the words lender for value are perhaps a little difficult to construe, because a loan is always going to be for value in some sense. And so you have to give the words for value some meaning, and that must mean value given by the other party to the contract that you're seeking to enforce. And in this case, the lender gave no value to NRL in relation to the mortgage. It's a purely one-sided transaction from their point of view, giving security. I'm not going to go through the facts on notice. They're set out in our case, and I bet it'll take me some time to go through them, so I won't. In relation to the other matters that were raised, purely as a point of fact, it's not the case that put to Mr. Dankou that he knew about the mortgage before the meeting on 28th of March. It was put to him that there could be no other reason for bringing the company's stamp, but it didn't go that far. In relation to the value of the charge, it is notable that it's page 4 of the document you have, clause 5.3. You were referred to the limited stamp value, but there is an express clause there that allows the bank to up-stamp the mortgage if there's any further amount owing. That's something that's in the hands of the bank. But if I come, there are really 3 points I want to make in relation to the arguments you've heard on the undue influence points. The first one was in relation to clarification by Mr. Gilkes about the point he was making about solicitors benefiting. And it does seem that the scope of the argument between the parties, in one sense, narrowed in the course of those submissions, because it was accepted there was a relationship of influence, and Mr. Gilkes accepted that you can have influence exerted for the benefit of a third party and that the benefit isn't necessary. What he ended up saying was, well, what's unusual about this arrangement? And that's a question which it's legitimate to ask, but it's one that the Court of Appeal gave an answer to. And while this court may have its own views, the Court of Appeal reached that decision. It was a decision that was open to them. But in evaluating that decision, it is a little difficult to see why the benefit to the solicitor either does or doesn't affect the usualness or otherwise of the transaction, or whether it calls for an explanation. And so where we are on this is it appears to be accepted that the foundation for much of the appellant's argument that you can have influence for the benefit of a third party in a solicitor-client context or in a solicitor context is right. And we respectfully suggest that is the correct approach in principle. And one can imagine cases where a solicitor could perhaps for their own innocent but misguided reasons, exert influence on a client to enter into a wholly inappropriate transaction. Loan sharks come to mind, or something of that kind. The undue influence jurisdiction ought to be available in such a case. The limiting factors are the involvement of the solicitor, the point I made earlier, but also the clarity as to whether or not there is something unusual about that transaction, and that there are plenty of contexts where the courts won't shut out a matter of principle, but may make clear that there are it's only to be exercised in rare cases. The case that immediately springs to mind are Article 8 possession cases, where the Supreme Court made that very clear. The remaining points I want to make on the undue influence arguments are in relation to the availability of agency as a route to establishing liability, even in a presumed undue influence case. We've already addressed you as to why we say that's wrong as a matter of, or it's wrong as a matter of principle to say that agency can't apply in such cases, and for that reason, many of the arguments that are advanced by the respondent about equating the position of the bank and the agent and deeming the bank to stand in the same attorney-client relationship and so on, all fall apart for the same reason. But what the argument came down to in the end was to say, well, it's all very inconvenient to have liability imposed on an agency basis, because it's going to make things difficult for banks who may not know what the position is with agents with whom they've entrusted their business. But the difficulty with those submissions are that they're not a basis for producing what we would suggest is an unprincipled approach to the imposition of liability. But also that it's not unfair to impose liability in those circumstances, because the bank has control over who they appoint as an agent. They can ask questions about what previous professional relationship there's been, and they can impose terms and conditions about whether or not someone does business in the future about someone with whom they've had a prior or existing professional relationship. And so, in answer to the question, well, what am I to tell the bank to protect themselves? The answer is clear. You ask those questions, you include those terms. And it's curious in one sense for the bank to be saying, well, they have no control over this kind of thing, because they have far less control over actual undue influence cases. Yet they've got, they accept that those will be suitable for the imposition of liability on an agency basis. And the argument is one which one can see is one that could be made much more generally and much more dangerously in one sense. If the argument is that because of the inconvenience of imposing liability for the acts of agents, such liability shouldn't be imposed, one can see the same point being made by employers if they're fixed with the liability of negligent employees and so on. And the fact is that rules like this are extremely well known. They operate generally as in effect a loss distribution mechanism, as Lord Millett explained in Dubai Aluminium, it's page 1512. And the consistent balance that the law has struck is that principals are liable for the acts of their agents. And that is a well-known principle, and it's one that is in this context, part of the distributive trade-off for the advantages of acting for agents. And so there's no principled or practical basis for drawing the kind of distinction the respondent suggests. I think that is everything, my lord, unless there's anything further.
Well, thank you very much, Mr. Westgate. And indeed, we're grateful to the advocates and their supporting teams on both sides for the depth and sophistication of the written and oral arguments which we've heard. And we will now take time to consider our judgment. In the meantime, the court is adjourned.